is Kaylor Williams, mediator for peaceful resolution. Today, I want to talk about one of the specialties and areas that we assist people to a dispute, and that is a family dispute. Family disputes can be anything from a divorce, it can be modification of child support, it can be far as it relate to conservatorship, it can relate to guardianship, and so many areas that are involved the family. But we specialize and work with families to assist them in their dispute. One of the things I wanted to go over today is just kind of go over the rules when it comes to a family dispute. Now, one of the things when you think about mediation is just going to read you just some of the benefits of mediation. It's a process which an impartial person, a third party, a neutral person, helps participants, his or her family, and others involved to a party reach an agreement. We find a mediation agreement or a mediated settlement agreement can save the parties time and expenses and can result in a more satisfactory and workable solution that can be obtained through court intervention. So what we find in the mediation, the process, is because each of the parties take part in their dispute and helping reaching a agreement, then we find that it's less conflict because even in a tense situation, we can find out we can able to facilitate a constructive communication. And when we do a divorce through mediation, both parties are taking part. Now, one of the things I do want to do is just go over some of the rules when we are doing a family mediation. So, number one rule is confidentiality. Everything, our communications is confidential, okay? And so what we talk about in that session, there are times we have a general session where we'll have both parties. But then there are times when we may break off and we caucus and we go into private rooms and we visit with each party. Those conversations are confidential. The only time we are required to report an instance is in the case if it involves abuse. So if it involves abuse, neglect, or exploitation of a child or the elderly or a person with disabilities, then that issue is not confidential, and we are required by law to make a disclosure and to report that. So when we talk about mediation, one of the things that we have these rules, and I want to go over these rules, and it states this: the participation, and when we talk about participation disclosure, parties are expected to communicate openly and trustfully, to share all information pertinent to the issues, and to follow instructions as directed by the mediator. Common courtesy shall be expected toward all in attendance and at the mediation. So we just want you, when one person is talking, we would like, if you're the other party, that you now interrupt and don't use profanity, and you allow that person to talk. And after that person's finished talking, then you'll have your opportunity to state your point. Okay, because we're trying to focus on issues and work toward resolution. The next thing is a safe place. We ask that all named parties, are not allowed to carry weapons or wear law enforcement uniforms in a mediation. No subpoenas, citations, writs, or other process shall be served or near the location of a mediation. Unless otherwise directed by the court, participants shall not be arrested during the mediation. So when you're doing a mediation, if you're a member of law enforcement, you're not allowed to come in with a uniform, okay? Or you cannot bring a firearm to a mediation. Next is legal. One thing, this is really important because we do some pro se divorces. And when we do those pro se, we don't have a We don't. The parties to the dispute do not have legal representation. They don't have attorneys. As a mediator, I am a neutral third party. I cannot give legal advice. Okay, we want to work toward a resolution, and both parties can agree, but we don't give legal advice. And it just says the mediator cannot provide legal advice to either party. The mediator is neutral and will not advocate for either party. If the need for legal advice arises during mediation, parties will be encouraged to discuss such issues with an attorney. So we are not attorneys. We don't give out legal advice. We will help you resolve by help developing communication, but we don't give out legal advice. Next, session attendance. Most family mediators are ordered and scheduled by the judge presiding over a court case. Parties are required to attend mediation at the court's order, time, and place. Parties are expected to mediate in good faith and to prepare to discuss the issues in the dispute. So you are required, if you've been ordered, when we do court-ordered mediations, or if a mediation is not court-ordered. If you and your spouse decide that you want to mediate, you want to go through mediation divorce, we can do that, settle that dispute. But we do expect, like you say, that both parties will be present. During the COVID-19, during the pandemic, we are able to do virtual mediation. So we are able to do virtual mediations and as well as face-to-face. Individual meetings, again, during the mediation sessions, will be in group sessions when both parties are present, or how many parties to the dispute. But at times, the process of mediation does require us to hold individual meetings with the parties. Such information shared during these times, what we call caucus, these meetings, is confidential. And unless approval is given by the appropriate person to share such information. Now, fees. Parties or counsel acknowledge and accept responsibility for fees that may be incurred. We do ask that at the end of the mediation that you do take care of the fees. So we do have fees, and we ask that you would take care of those fees as soon as the mediation is over. Also, non-named individuals, and we have to go over this. Prior permission must be obtained before any individual who is not actual parties to the matter being mediated or their legal counsel may accompany a party to or otherwise participate in a mediation. Even if prior permission is granted, the mediator does reserve the right to request any non-party to leave for the duration of the mediation. In order to assist the parties in reaching an agreement, it may be necessary for the mediator to interview other persons. If so, the mediator will discuss any information and inform everyone involved. Such discussions are confidential. We stress that only the parties that are involved in the dispute would, for us come to the mediation, and it helps that by doing this, that helps us to have a mediation that is productive and that is allow us to just transition and move smoothly. Okay, that right there is just some of the ground rules. There are some other rules in regard to a family mediation, a family custody, visitation, divorce, or modification mediation. The first thing, and this is really important, is family violence. If parties are requested to disclose past or present family or domestic violence to the mediator at the beginning of the mediation, okay, so that's critical. That's important. If there's any family violence, we really would like for that to be we're made aware of that before we have the mediation, and that could be as far as in a call or email. To let us know that there was family violence, so we may be able to put some safety parameters in place. Number one, also, as far as financial advice during a family mediation, we cannot provide financial advice to either party. The mediator is neutral and will not advocate for either party. If the need for financial advice arises from the mediation, Parties will be encouraged to discuss such issues with an accountant, a forensic accountant, a certified financial divorce analyst, or someone who will be able to give you good objective advice. Also, bankruptcy and taxing regulatory agencies. If you have a pending matter in bankruptcy court and you affirm the stay has been lifted and the court has approved you to conduct a mediation. Additionally, you acknowledge that your agreement is not binding upon taxing regulatory agencies. Most of the time, if we have someone is going through a bankruptcy, what the issues may be already part of that bankruptcy, and we at that time would stop the mediation, and that needs to be cleared up. So if you're going through a bankruptcy prior to mediation, please let us know that you are going through a bankruptcy or you have different assets that are part of that bankruptcy. Next thing is best interest of the child. It is an expectation that all parties will participate within the best interest of the children for the entirety of the mediation. Okay. Then we talk about the communication between sessions and notice of a settlement. If mediation is continued to another date, the mediator will not discuss the mediation with either party or an attorney in the case between mediated sessions. If the parties settle the dispute before reconvening the mediation, the parties or the attorneys will immediately inform the mediator of the settlement. That just basically means if we set a future date for mediation and we weren't able to just take care of every issue and we have to set it to a future date, we asked in between that I will not have any contact with either attorney or if either parties to a dispute. Cell phones, because the mediation is confidential, everything discussed is confidential, we ask the cell phones immediately be turned off during the mediation, and we asked that you do not record the mediation. You cannot record the mediation. Everything is confidential. If you have a cell phone, it could be something that is subpoena you left open on. So we ask that you turn the cell phone off when you come into the mediation. We know that if we're doing a virtual mediation, we also ask that you would abide by those rules as well. And then reporting the outcome of the mediation. If the parties or the mediator terminates the mediation before an agreement is reached, the report to the court will reflect an impasse. If the parties reach an agreement during the mediation that resolves all or part of the dispute, the mediator record a family mediated settlement agreement that will state the terms of the agreement. The family mediated settlement agreement will be given to the parties and their attorney, if they have one. Parties will attend mediation without counsel, may sign the agreement at the mediation, or may wait to sign the agreement until after their attorney has reviewed and approved the agreement. Before signing and thereby executing any agreement, parties have the right to have it independently reviewed by a lawyer. Once signed, the family mediated settlement agreement may be enforced as a judgment. That right there will cover just when we cover the family mediation. We will also, in our next video, we will talk about business disputes and the process and how we work toward business disputes. Look forward to talking to you soon. If you're in a dispute, before doing anything that is that you regret later, or as an alternative to going through the courts and hashing it out in front of strangers, give us a call at Peaceful Resolution LLC and let us sit down with you and the person and the parties to your dispute as we work toward a peaceful resolution. This is Kaylor Williams. We'll see you soon.